Are you recording? Are we good? All right. Welcome, everyone. I know there are a couple of people who are stuck in traffic and running a bit late, but we are core 8, and we do have enough people present to coordinate the presentation, or at least the first presentation. So we are going to go ahead. If I can just briefly ask members to join us in a moment of silence and reflection. Thank you. Thanks very much. Members present, if you can just introduce yourselves, starting with Member Constable.
Good morning, Chairperson. Good morning, colleagues. My name is Noel Constable, and I'm a member of this committee. Thank you.
Good morning, everyone. Peter Johnson, member of this committee.
Good morning, Chairperson. Derek Hills, member of the committee.
And I'm Dave Bryant, Chairperson of the Standing Committee on Local Government, Environment and Development Planning. We do have 2 apologies from Minister Burdell and Mr. Gerber, the HOD. And then if we can just introduce officials who are present. Is it Rebel, Mr. Rebel, and Mr. Munro, and the others, if you can just introduce yourselves as well.
Morning, Honourable Chair. I'm Theo Rebel. I'm a town planner in the Department of Environmental Affairs and Development Planning. Been intimately involved in this process amending the Land Use Planning Act. Thank you.
Good morning, Chair. Kobus Munro. I'm Director of Development Management. This program falls under me. My Chief Director, Ms. Mabansela, is, I think, also in traffic, but she is on her way, but we can start.
Good morning, Chair. My name is Tanya Faber. I am a State Law Advisor with Legal Services, and I'm the Legal Advisor to the department. Thank you.
Morning, Chair members. My name is Solly Martinez. I'm also a State Law Advisor. Recently joined Legal Services. Thanks.
Member Masipa's in traffic, and I think Member Stoffel was not able to attend, but she said.
Advocate Marstorp from
also in
Legal Western Cape Provincial Parliament. He's on his way.
Right.
Thank you, Mr. Chair. Can I just ask my director to just do the intro to this?
Of course.
There's not much. I think the introduction will be in the slides as well, Chair. Just apologies from my HOD who would have loved to have been here. So what we've done is a very short presentation, Chair. So this is not a line by line, but I think Theo will repeat that. On the general aims and principles that we're trying to address with this bill. It's not a very controversial amendment to the bill. I think Theo will go through it, and obviously, if there are questions on specific aspects, we can come back and workshop some of these aspects properly. And I think, as Johan has indicated, we need to decide how to take this forward. But I think you will take that decision also based on the public participation that's already taken place with this process. But I think I'm going to let you run through it, and I think the questions will then come from the presentation. Thanks, Steve.
Thank you, Mr. Chair. Thank you for the opportunity. Yeah, we as a department, the content that I intend to cover here would firstly be to have a brief look at the request that was sent to us. and then try and put the whole amendment bill in context. And for that purpose, we will have to look at the background to the planning law reform that we've seen over the last number of years. We will then have a look at the aims and objectives of the bill as it stands at the moment, and also some challenges that one has when you draft legislation like this. And then the last bit would be to link the amendments that we propose to the aims and objectives. And I hope that that will be sufficient for what the committee needs from us. So in principle, it's a briefing on the aims and principles of the Western Cape Land Use Planning Bill that seeks an amendment to the Western Cape Land Use Planning Act, which we commonly refer to as LUPA. And LUPA is the successor of the provincial act that replaced the former land use planning ordinance. Note the difference between act and ordinance, which was in operation for close to 30 years. So as my director has indicated, it's not a line for line discussion, but we will get to some of the amendments to see how it links to the objectives. And then secondly, it is that we note that this is the second amendment to LUPA. The first one was, and I'll get back to that, in 2010. So the act has been in operation now for 10 to 11 years. To put the land use planning legislation in a bit of perspective, in the national sphere of government, and these mandates are, as far as I know, regulated in the Constitution, specifically Schedules 4 and 5B. Be that as it may, the National Department, Rural Development and Land Reform, custodian and drafter of the Spatial Planning and Land Use Management Act, which is a framework act regulating land use planning. And then also what has an influence here is the Municipal Systems Act, the MSA that we know, where the IDP, the SDF and bylaws and so forth are regulated. And one can also add to this list the PAJA, the Public Administration Justice Act. Then in the provincial sphere of government, where we are here, is the Western Cape Land Use Planning Act. And then also in terms of the MSA, we are able to make standard draft bylaws. And the reason why I say that is that that has an impact on how land use planning is regulated, especially in this province. And then the bottom one, although it's not the hierarchy, is the municipal sphere of government, where they make and adopt municipal planning bylaws. And for this purpose, they may use the standard draft bylaw that as a province has drafted, or they can draft their own, or they can amend it. So before we get to the background to the planning law reform, I just want to take a step or so backwards. And it's about 30 years back, but I'm not going to take much time on that. But prior to 1995, there was no national act that regulated land use planning. Each of the provinces that were there at the time had their own ordinances. Then in 1995, the Development Facilitation Act was promulgated, and that was a national act, and it ran alongside all the provincial ordinances. But it was a national process to try and regulate planning on a national level. It was a controversial act, and mainly because of the processes that it followed and the tribunal that made the planning decisions, which was not a municipal tribunal. It was a tribunal on a provincial level that took municipal planning decisions. And that is where the conflict started. And then in 2010, this act was taken right up to the Constitutional Court, where there was very specific rulings about what is municipal planning. and how far can a national government and a provincial government regulate planning. And part of that decision in 2010 was that the Constitutional Court gave national government 2 years to come up with a national act that complies with this. And that is when the Spatial Planning and Land Use Management Act, the National Act, SPLUMA as we refer to it, was assented to in 2013, and it was promulgated or commenced in July 2015. But in the meantime, in the Western Cape, we didn't sit still. We were drafting the Western Cape Land Use Planning Act, which had a whole lot more provisions in it than what it has now. But for us, it was also a learning curve on what can we regulate and what can we not regulate for. So eventually we published LUPA in the Provincial Gazette on 7 April 2014, but it didn't come into operation in the whole province on one specific day. We had different dates for commencement in different municipalities, and that was about a 2-year period. And this staggered implementation was done for a very good reason, and that is we wanted to make sure that municipalities were ready to take on the responsibilities for municipal planning, which has been in the Constitution for quite a number of years, but nobody really understood it or implemented it correctly. So we had to make sure that municipalities have bylaws, that they have a tribunal, that they have authorized officials, that the appeal authority is in place, all those sort of things. So that took in those 2 years, 2015 to 2016. And then in 2021, when disaster struck the country, we had to amend the LUPA, and that was to delete one specific clause, and that is 44.2b, and that is a clause that, in simple terms, requires the land use planning applications to be to be notified of by registered post. And in the COVID pandemic, that was obviously not possible. So we had to delete that, and eventually this whole section 44 is also part now of what we want to take out of the Act. So it was actually over-regulating, and it had unintended consequences. And so, yes, the second amendment is what we are busy with now. And just a bit of process that we as a department followed. The draft bill that we had at the time was officially gazetted for public consultation in November 23. We received a number of comments and proposals, which we worked in. And then we had 2 other rounds of consultation with stakeholders, not in the Provincial Gazette, but all the municipal planning heads, the councillors, consultants, other departments, and SOLGA as well. And we did that on 2 occasions. The first one was in April 24, after receiving the November comments. And after the April circulation, we got another couple of comments, and which we worked into, and did a 3rd round of consultation in September 24 in the same way. So it is a process that has gone through quite a process, and we went, I think, out of our way to make sure that we get input from the industry and not have just a top-down, this is how we do it type of thing. So that is basically the background to where we are with the planning legislation. So taking all of this into account and what municipalities did and didn't do and could not do, and what LUPA at the moment has in it, the aims with this specific amendment bill is to provide for more municipal discretion on land use planning processes. And what is very important to us is to reduce the administrative burden, or red tape as some people refer to it, and to avoid further overregulation of processes. Then obviously everybody doesn't understand everything the same way, so we had to make sure that we give clarity to certain provisions. and then also to add and improve on certain terms and definitions. And lastly, and most importantly, to provide more flexibility and autonomy to municipalities in respect of land use planning processes. And there we can just mention the example of how you do public consultation on what type of applications, and not that province specify for a rezoning you do this, for consent you do that. You must do certain things that PAJA prescribes, and we don't want to be over prescriptive. So that just puts that into perspective. So the issues that informed our process, and we've sort of categorized these, they are at the bottom there. There were issues about clarity and improvement. There were issues about reducing red tape. There were specific requests by users, I think typically of the city of Cape Town, that wanted certain things in or out. Eskom wanted certain things in or out. That advised the process. And then there's a number of issues that we as a department, in our own experience, based on inquiries that we get from municipalities, or our own reading and understanding and experience with the Act, we've identified our own issues for consideration as well. So now, amending an Act that operates between the national sphere of government's legislation and, on the other hand, the municipal sphere of government with the bylaws, is quite challenging. It's interesting, but it is challenging, and it requires us to have a balancing act between overregulation and ensuring necessary and defendable minimum requirements. And then also ensure that we don't overstep the mandate of municipal planning. Here we have been advised by a large number of court cases, as well as legal opinion that we sourced at the time. And then ensuring that there will not be unintended consequences. That is always a thing that one has to keep in mind, but you cannot always 100% predict that. And then also ensure that we are aligned with SPLUMA and other legislation, such as the MSA and PAJA that I have referred to before. So that, Mr. Honourable Chair, is the intro part of my presentation. The next 8 slides will merely be indicative of what we propose in general terms, and how it links to the aims and objectives. If we look at this one, it concerns Section 1 of the Act, and Section 1 mainly are the definitions. And there are 3 new definitions that we've proposed on consolidation, on inclusionary housing, and defining the Spatial Planning and Land Use Management Act, which we now use in the Act, and therefore had to define it. And then there are 2 definitions which we amend. The one would be on restrictive condition. With that, we mean the restrictive conditions that appear in a title deed of a property that often specify what you can and what you cannot do. And then also substituting the definition of subdivision. And there was a very specific reason for this was to exclude the instances where the Sectional Titles Act is involved. That was perhaps an unintended consequence that came from the definition of land in the National Act itself. Then on the second slide of this, there are various clauses in the first line there that deal with a number of sections of the Act, and it sounds complicated, but it is a technical amendment where an SDF, a spatial development framework in a municipality, is adopted, but it doesn't call for the adoption of an amendment. And that is for the colleagues dealing with spatial planning, both in the department and at municipalities, a problem. And so these amendments basically mean that you adopt also an amended SDF. So that is to provide clarity and certainty. Then clause 19 or section 19, which also deals with the SDF, but and the main thing there is when is a land use application consistent with an SDF and when does it deviate from it? And if you want to, I can go in a bit more detail, but it is to provide more clarity there and also to provide a bit more flexibility in municipal decision making there. And then we get to clauses 7 and 9 of the bill, where we propose that municipalities, when they consider applications for rezoning, consent uses, departures, or a consolidation, that they consider to impose a validity period for the approval as a condition of approval. Because this has technical implications later on if you want to extend these things. And also that in the previous legislation under LUPO, it was a automatic lapsing, and we want to make sure that municipalities have a bit more autonomy and flexibility in this. And then it also removes references to section 43 and 44 of the Act, which deal with the serving of notices and the publication of notices, and I will get back to that. Then clause 8 deals with section 36 of the Act, and that deals with the processes to subdivide land, be it a single subdivision or a subdivision that equates to township establishment. And this is for us a quite important one, which we want to make sure that there are uniform processes and principles to apply for the consolidation and the subdivision and the confirmation thereof. Then we get to restrictive conditions. I've indicated that restrictive conditions we refer to as conditions that appear in title deeds of properties. The main thing here is that the administrative burden that municipalities have as it is at the moment is that in a lot of townships you have title conditions that relate to building lines, etc., and those are in all the title deeds of properties in that township. And if you want to amend or remove that, you need to notify all the owners of that. And that is onerous, and that is also just applicable in the Western Cape. None of the other provinces in the country deal with it that way. So the suggestion now is to do personal notification, a serving of a notice, only to those that are materially and adversely affected. So there's the discretion that the municipality has on who will be those persons. But the application will still be advertised in the press. So the owners of land in the wider area can still participate in the process, but they will just not be personally notified of it.
Chair, can I just interject here? On this specific issue, because it was an uncertain area for all of us. A lot of court cases in the city of Cape Town was about people not being informed. You had the Camps Bay Ratepayers Association taking the city to court on numerous occasions, and it was about this clause. So we appointed a senior counsel to advise the department on this specific topic, Advocate Ron Pask, who is one of our best, so this is a real game changer for us if we get this through, especially for the city. The city is currently dealing with numerous court cases as we speak. So yeah, this one is one that I just wanted to highlight for the committee.
Thanks, Mr. Munro. I was the ward councillor for the CBD for 9 years, so I know some of these cases. I think the challenge obviously is going to be who defines whether or not something is an adverse or has an adverse impact. That's probably going to be the challenge. But anyway, we'll get to that at a later stage. But I see where you're going. Sorry, back to you.
Thanks, Honourable Chair. You will then know that in Camps Bay, if you miss out on notifying one person, then you get to court and the application goes nowhere, and a lot of taxpayers' money is spent on that. Then the fifth slide of this, Section 40 of the Act deals with conditions that can be imposed, and we've widened the list of possible conditions to make provision for inclusionary housing, which has been in the news for quite a while for various reasons as well, and to provide for coastal protection and measures to mitigate the impact of a development, again, as additional conditions of approval that can be required. And that, again, improves flexibility and also the autonomy of municipalities. Section 41 is a small one where, again, the reference to the serving of notices is removed when you amend a condition of approval. This is a typical example of where the administrative burden and the cost of an application is reduced. We remove the requirement that a bondholder's consent must be submitted with a land use application. It has been in land use application ever since I started practicing planning, but there's never been any reason for it specifically. And often when people apply for something, but their bond may be in arrears, then you don't get the bondholder's consent and nothing can happen thereafter. So maybe the banks must do their own homework. Then section 43 and 44, and Kobus, if you want to interject there as well, you're welcome. That are two fairly long sections in the Act that deals with the publication of notices and the serving of notices. And it is very prescriptive in it that it says for a rezoning you do this, for a subdivision you do that. And it is overly restrictive, and it is a blunt instrument, because there may very well be instances where you don't really need to do these things. For a very small amendment, the Act says you must do it. So it doesn't take away the need to do public consultation, but the Public Administration and Justice Act has adequate provisions for that, and there's very little reason for us to continue regulating it this way in provincial legislation. And it's also, when we drafted the standard draft planning bylaws, it's in there as well in detail. And municipalities follow that. They are scared to not do public consultation. So we are comfortable that municipalities deal with it properly and that it's properly regulated, and there's no need for it to be in this Act any further. Section 45 of the Act deals with when municipalities have to refer applications to the province for comment. That is perhaps also overly prescriptive, and it regulates instances which are not applicable anymore. For instance, where no SDF exists. I mean, everywhere in this province, all municipalities have SDF, so there's no use to continue for it like that. But it was not like that when we drafted the Act initially. And then any development that affects the provincial functional area, that remains in the Act. So that's in those instances, municipalities still have to get comments from the department or from the province. And we still leave it in that for any instances where they think it necessary, they are welcome to get the comments of the province for applications. Then sections 47 and 45 deal with the period in which the province and other organs of state, when they are asked for comments, how long they have to do these comments. And this has always been 60 days. But there's not really a reason for that to be 60 days. And we propose that it be reduced to 30 days. but still leave the option that it can be extended. But this is in an attempt to speed up development and to shorten timeframes, which is something that you often hear. Section 49 and 50 just deletes the references to structure plans, which were the predecessors of SDFs in the Lupo era. So there are no structure plans in operation anymore, so that can be deleted. Section 50, that is a minimum requirement here, the notification of municipal decisions. If a municipality's tribunal or its authorized official takes a decision on a land use application, how do they notify people of it, and which people do they notify? Previously, it was quite wide, but the minimum requirement that we suggest here is to those people that have objected to the application. So they have shown their interest and they need to be advised so that they can appeal if they want to. But we also include there that the letter of approval or the letter of refusal must include the reasons for that decision. Because if you don't do it that way, then PAJA gives you 90 days to ask for those reasons. And again, then you draw out the appeal process. Section 54 deals with the communication of a decision of the HOD on applications that must come to the province. And that is in a very similar fashion. The main thing here is that we remove the compulsory requirement that it must be, that the decision must be published in the Gazette. There's an enormous cost involved in that. It's often more than what the application fee is, and it serves very little purpose. The second last slide here. Sorry, I skipped this one. Section 60 of the Act, and with that, we had, in the 2 years of COVID, had detailed experience in how overly regulated we ourselves are. And that is when there's an emergency situation and the minister needs to authorize municipalities to deviate from certain provisions of the Act. And this again was mainly because of the section 44(2)(b), which we simultaneously had a process running. But if something like that happens, within 48 hours, we must publish a notice in the Gazette. We must advise Cabinet, and then in 14 days have a report to Cabinet. Now, this we had to do 4 times in COVID, and I tell you, it is very onerous, and the same can be achieved with much less of a regulatory framework. Then the other thing that is typically at section 61, which is a issue that we've identified ourselves, is where certain subdivisions and consolidations are exempted from municipal approval. And one specific one here is where you subdivide agricultural land that is subject to Act 70. Which is the Subdivision of Agricultural Land Act. So if the Department of Agriculture then approves of a subdivision, what would the need therefore be for municipalities to do the same? The problem is that that act doesn't regulate the consolidation of farmland. So whilst you can subdivide it without municipal approval, you cannot consolidate it without. So it is to make sure that unintended consequence is not there anymore. Section 67, also relatively important one, where we try to make sure that processes that were followed in other legislation for the same land, for the same reason, that those processes can be regarded as sufficient for a decision that has to be made in terms of this act. The hurdle that we sit with is that it initially said in terms of other legislation only if it meets all the requirements of FLUPA. Now that if you do that, then you don't have any advantage out of it. So the suggestion is that the municipality or the HOD has the discretion to decide on a land use application on the basis of a process followed in terms of such legislation or bylaws without the restrict compliance with the requirements of LUPA. And that is when it is justifiable and reasonable, and then there are a number of relevant considerations that is proposed in this instance.
Chair, can I interject?
Yes.
Yeah, this is an important one that we as government struggle with a lot. All the departments want to do their own little thing in their own department with their own rules, and we are continuously writing new laws. But what most of the legislation have this clause in that you are allowed, let's say there's an EIA, there's a really thorough environmental impact assessment, the communities were all thoroughly participated in the process, and now the same application come to the municipality, and now you go back to the same community, show them the same drawings, but it's now the planning process, and then heritage and agriculture. So what this does is to say, look at that process, and you are allowed to, based on that process, just take your decision. I mean, that can potentially cut years off. But it is something that won't be easily misused, but it is, and that's why we have to regulate it properly. But the Water Act, the EIAs, the heritage planning, all of them have this in. And the chair may recall that our comments on the new PDALA, Preservation of Development of Agricultural Land Act, that was our main concern, that act doesn't have this clause in. So that typically in developments, you have all these hurdles to jump over, all these acts that you have to get approvals or permits, and you want to integrate as much as possible these processes to run not only concurrently, but to take decisions together. So we're not here to discuss PDALA. I know that would be discussed later, but that is a shortcoming in that act that we need. Well, we have from the department have asked the department, but it's important that this thing works. So we've fine-tuned it just a little bit. So thanks just for that bit of clarity.
But yeah, that proposal is also not a compulsory one. It is an option. Because obviously, if there's a very complicated application with a lot of objections, then it's perhaps not the suitable way to do it. But there may be totally different circumstances where it is useful to work. Then lastly, I'm not going to go into any detail that there's a small textual improvement that we want to do there in section 68. It talks about terms and conditions, but LUPA doesn't operate on terms, it's conditions of approval or not. And then section 28 is transitional measures that are proposed to make sure that there's a smooth transition from the current dispensation to when this act is in whatever form published. And lastly, a short title and a commencement date, which we suggest is a date that will be published afterwards. Lastly, Chair, obviously these amendments will have downstream effects on the set of regulations that this Act has. We're currently busy with to look at that and to advise our Minister on that. And then we also need to be wary on how these changes affect the planning bylaws of municipalities, because that in itself is a process to get 25 municipalities to amend their bylaws for this, and it takes up a lot of their time, it takes up a lot of their effort. So I'll wary not to put too much burden on municipalities in that, but it is unavoidable. There will have to be some, even the current process of amendments to the Spatial Planning and Land Use Management Act may necessitate that. So hopefully within the new year, we would be able to, in one go, advise on both of them and get our municipalities up to speed with all of this. And that is it. Thank you, Mr. Chair.
Thank you very much. Look, we don't have all of the information at our fingertips at the moment, so I don't think we're going to be engaging in sort of a debate over the content of the bill specifically. Although I do have one question, which is in terms of the inclusionary housing definition. What is the inclusionary housing definition? Because obviously we have inclusionary housing, we have affordable housing, we have social housing, we have all these different terms that fly around. And I mean, my understanding of inclusionary housing has always been that, you know, it is a way to promote development on the one hand, but at the same time, you know, include a social component as mandatory. So you explain how you've gone about defining that, because I do think that might be something that is a point of discussion, shall we say.
Yes, Chair, let me read it first. So inclusionary housing means a spatially targeted mechanism that relies on the regulatory system of development planning, which is just this process. So it's not a housing mechanism. It is a planning mechanism. To oblige property developers to provide affordable housing for sale or rent within their development or at an alternative location determined by the municipality, or they can provide an in lieu financial contribution. So what it is if you look at they talk about the gap, the so-called gap market. So you've got your state-funded housing that goes up to 3,500 Rand income. And then thereafter, the banks will only look at you if you earn about 30,000 Rand a month. So between 3,500 Rand a month income and 30,000 Rand a month income, that's the so-called gap where nobody is actually interested in you. And the developers are also not interested in you, so that they don't build something that's less than R1 million. So what this does is it says, okay, so the definition of affordable is exactly that, somebody that earns, so it's not somebody with no income. It's somebody that actually does have a job and earned up to 27,000 Rand, which is defined nationally by our banks. So what this does is to say to a developer, you cannot skim the cream of the crop in my town and just provide housing for the rich. If you develop in my town, you do so because we provide roads, we provide parks, we provide good administration, and you capture that value for you, and then you only sell to the rich people. So the land value capture movement, which is driven by DAG in South Africa, is a worldwide phenomenon. To say, developers, you are obliged, when you reap the benefits of developing in an urban area, to not only provide for the rich. And we're going to ask you to please, in that building of yours, to also provide something that's affordable. We're not talking about giveaway houses. We're talking about something that is just affordable for a nurse, for a official, policeman, teachers. You talk about that category. So it's an attempt to address the gap market. It does not take away the responsibility of municipalities to provide that themselves. I think if you do the maths, you'll realize that if you take 10% or 20% from developers for gap housing through this mechanism, you're only going to scratch the surface. You're not going to get close to dealing with the housing problem in the gap market. But it is an important spatial transformation tool to get our societies more integrated. Sorry.
Yeah, that's fine. So, Mr. Warren, sorry, I don't want to get too discussion-y, but I think it's important just to get it. So, I mean, is the intention then to apply that across the board? Because, for instance, if somebody was putting in a luxury development in an extremely affluent area, then you would use the other provision within that definition to say, great, it is going to be maybe a little bit more difficult for you to build spots for nurses on Clifton Beach, but perhaps you then would consider building it in a close-ish by location that is a little bit more affordable. Is that correct? But I mean, is it something that is intended to apply across the board, or are there any certain segments of development that would require it?
No, it wouldn't apply across the board, and it's obviously a municipal decision. And that's why we're doing housing market studies at the moment to see where is that, what they say, price cliff, where does that happen? And also the city of Cape Town, their preference is to get the contribution in lieu, in money terms. The city will then buy land and make that land available to social housing institutions for typically R1. So there's a piece of land. So now you build only in that price range. So we try to keep it here as wide as possible, so that it's a soft landing, because there's a lot of resistance. There's a lot of resistance against this. I think the industry has calmed down a bit. They now understand that this is coming, and it's not a South African thing. It's across the world. In fact, this started in South America. So to provide as many options as possible. Stellenbosch is the first municipality who's actually implementing it. Johannesburg was just before them, but in the Western Cape, Stellenbosch is. City of Cape Town is still considering their options. As I say, they don't like at the moment the fact that you force a developer to put into that development, because that means sometimes you place people in areas that are not suitable for them to get to work. Because you're talking about nurses, Wraithby, Kylmore is on the outskirts of Stellenbosch even. So for an upmarket developer there, and Boschendal is one of the latest ones that have to put people in there with no transport is not going to work. So rather than provide it elsewhere or give the money to the city, that the city do it.
Sure. And I think that is the gap between activism, obviously often very well-intentioned activism, but the practicalities around the developments, which I think often don't always gel. Sorry, one last question from my side, and then I'm going to open up for any others. I know there is, in terms of valuations, often an option for somebody who is developing for a social housing / inclusionary / et cetera, to get it at a reduced rate up to 10% sometimes. Would that apply for somebody who is doing inclusionary housing? Because these are the sort of definitions that become a little bit ambiguous, and I think is probably one of the reasons why people feel a bit awkward. I know I'm throwing a much bigger conundrum your way, but I just think it's all worthwhile us factoring this in while we're applying our minds.
Yes, Chair. So, the inclusionary housing has been a huge debate. I mean, it started in 2005 already, and there was so much pushback that it completely was abandoned. But I think the lobby groups are now gaining momentum, and it is the right thing to do. It's just to get the details correct, as you say, and to get the also the tools, like whether you allow a person to sell it, because that I think is the biggest challenge. If you can land it in a rental pool, that's the best. But developers don't like rental pools. They want to build their stuff and move off. And to force a developer now to own a few hundred of these units, and so who takes care of it? You donate it to the city, or what do you do? The social housing institutions, of course, is going to play a huge role in this. So if you can have these things in the rental, is probably at the moment the best. But we're finding our way, and as I say, 2 or 3 municipalities currently are implementing it and having problems. Especially the big thing that you influence here, Chair, is the land value, because a brick is the same cost, whether it's for a lower cost unit than for a higher cost unit. Gold taps and stuff, yes, but if you see, why does a unit in Stellenbosch cost 6 million, and exactly that same unit in Wellington will cost you 2 million. You know, it's the land cost. So if you can introduce the inclusionary housing at a specific date and say, everybody understand, from this date onwards, we are going to impose this condition on all developments. Then developers are able to negotiate with a landowner to say, listen, I understand you want so much for the land, but I need to provide inclusionary housing. So I can't sell those percentage of units at the top price that I want to. And that will start bringing the land prices down so that people can play in this affordable market. What will be unfair is to retrofit this to a person who's already, and you will recall maybe the Harbour Arch. Yeah, I think the Harbour Arch had to give away 100 units. I think it was 100. But that was sort of after the fact. They already paid the land. It was a huge fight. So how you introduce it is going to be tricky. But from our perspective, we're just making it possible in this framework legislation to say to municipalities, this is a possibility that you could now implement if you have all your ducks in a row. It wasn't there before. So the details will come out in the municipalities. As I say, Cape Town will probably go for the money option rather than forcing the units to be scattered all over the city. Sorry, Chair.
No, that's great. That's great. I think it's a nice discussion. Colleagues, anybody want to make any inputs or questions, queries? Member Masipa, we got Member Constable, Member Vessels. Member Masipa first.
Thanks, Chairperson. Good morning, colleagues and officials from the department. I'm sorry I was a little bit late because of the traffic. I think I get the gist of this amendment, which I think are very important in terms of really ensuring that we reduce the red tape. I know you spoke about the pedal. I worked on it from NA. And we approved it, but we still a little bit concerned because there are a number of regulations that must still be developed. I'm just questioning whether, you have really considered that, after this amendment, PDAL's regulations coming in might also, impact on the amendment that you have made, because, for me, this is very important, is to make the job much easier, to reduce the red tape, to ensure that, we've got the smooth running of the business in doing developments. But the challenge is that with the PDAL, if you look at it, it requires some structures to be formed at the province, where the minister is obviously coordinating those kind of functions. And I think the big question that I had was that, wouldn't that be trampling on planning as well? That you might find that, you are taking jobs that are really primarily, in the planning space. Although, in principle, we agree that we got to protect the agricultural land. But your challenge is that how far do you go, especially with regards to planning, which the city, the municipality has got an exclusive right to do that. The second one, obviously, is regarding the recent events that we have had in George with regards to collapse of the building. As you want to reduce the red tape, but at the same time, I think the question of, the shortened period of ensuring that you get feedback and you move with the next phase of development. As you know that, with any building or projects and so forth, there are really quite a number of, players and challenges. So have you thought about it? Because I'm not sure about the report of George, but I'm just saying that, getting all the partners, because there are just so many players in this thing at the end, and ensuring that, there is enough space for everyone to participate. I just wanted to hear if that has been really thought of as well. Thank you.
Do you want to take the questions one by one, or do you want to take a group? Okay. We've also got Member Nkondlo online, who has joined on the virtual platform that we set up. So welcome, Member Nkondlo. We'll take you as the fourth input. I think we'll take 2 questions, and then we'll take another 2. Next was Member Constable.
Thank you, Chair. Mine may not be a question because I was answered at the end of Mr. Abel's presentation with regards to municipalities, because I'm always worried when it gets to acts and legislation that the capacity of municipalities, especially rural municipalities, is not up to standard with regards to the implementation or even the establishment of bylaws in line with this. So I'm happy that he said that they will then go next year to specific municipalities. The other question was also with regards to the special development plans. And he also said that municipalities, all the municipalities in the Western Cape, because it's always good to hear words like you want to reduce administrative burdens and overregulation and flexibilities and autonomies, but municipalities are not really capacitated to implement or to establish bylaws. So that for me is it's a good thing if province can assist municipalities, because rural municipalities does not even have town planners. That means that function there is placed in a technical department where there is no capacity, where there is no skills. And I believe when we structure this and when we approve this, we must also include the support that we give to municipalities. That is just a comment from my side. Thank you, Chair.
Thanks, member. Mr. Munro, Mr. Rebel.
Yeah, thanks, Member Masipa. The PIDALA, or I don't know, we will still get used to the new acronym. Preservation and Development of Agricultural Land Act, which has now been assented to. We're waiting for those regulations very anxiously, because exactly what the member is saying is going to happen, I'm afraid, is that, but similarly to if you look at environmental impact assessment, for instance, if a farmer wants to build a dam, it triggers more than one act. You know, there's the Water Act and the EIA. So, and the similar thing is going to happen here. If a farmer wants to build a huge atmospheric controlled cold storage facility, for instance, for export of apples or something, the municipality have to approve that building. But this new act is going to require approval as well. I think it's unavoidable that there's going to be, again now, these overlaps, so that a new proposal on a farm, which is to be regulated by the new PIDALA Act, might trigger 2-3 other acts as well. And that's why I mentioned earlier, if we can just get these things to work together, to run public participation, for instance, at the same time, because people get tired of public participation. If you see the same thing for the third time in the press, you don't react anymore, because you don't understand why is it the same thing. They don't understand that it's another act, and you got to have an agricultural hat on for this one. For that one, you have to have an environmental hat on, and for that one, you have to have a municipal hat on. They don't understand those differences, and people do not then participate after a while in these processes, and you lose a lot of time. National Treasury has done an investigation into the length of these applications, talking about major applications, as well as UCT has done it. And the average, you've got to go through all these legislative processes, 6.5 years. Now you can imagine a developer that purchased a piece of land for 80 or 100 million rand, the interest on 6-7 years. And what PIDALA is now doing is adding another year. That's how we understand that it's necessary. We also understand that it is going to overlap with some other legislation, because they've got their own constitutional mandate, agriculture. So you are definitely going to require municipal approval for a subdivision as well as a PIDALA approval for a subdivision. But we're just asking that these things somehow dovetail, overlap, sequence, and so on. With respect to the George building collapse, I think the main problem there is obviously the building legislation, and then the NHBRC registration and all the things that happen after that, which is not part of our process. This act will rezone it from a house to a block of flats with conditions. Yes, the checking that those conditions are complied with is incredibly important. We deal with it in one section in the act where we have strengthened the regulations when a person may sell. So the municipality must all checks and balances so that you as an unexpected citizen don't buy a piece of land that doesn't comply with the regulations. But we are, just as a side note, Member Masipa, the Western Cape government has, through another process, now agreed to start with new building regulations. You know, that act is so old. I think it's 77 or somewhere there. And with our national Deputy National Minister Whitfield and the Premier, together with Cape Town Mayor, has agreed that we are going to now start drawing up new as the Western Cape, and they want to use that for the rest of the country if we make a success of it. So the pressure is on us to do that, which would deal with things like this. And yeah, Honourable Member Constable, yeah, our main job is to support the municipalities. So we drive around this province whenever municipalities are struggling to go and assist them. We sit on their tribunals. We assist them with individual reports. We assist them with comments on difficult things, because I think it's the backbone on why the Western Cape in the planning fraternity works well at the moment, is a strong province. Initially, when they got their freedom, when the municipalities had to, you know, they were able to get rid of province. They were going good riddance. Now Big Brother is gone. So for the first 5 years, we didn't see them. They were just gone. But slowly they've come back. You know, they realized that it's very alone out there. You're the only planner there. You got very angry and, let me not add more words, councillors. That's looking over your shoulder all the time. People have got different motives for what they want. And planning, unfortunately, is a tool that's kicked around between politicians, often for completely different reasons than, you know, the development that you want to see. And they have, one by one, even difficult municipalities like Hermanus, you know, Overstrand and so on, have come back and say, province, we don't know how to think about this thing. Help us think this through. Often we tread on legal opinions that we don't have the capacity for. But if there is money and or it's important enough, we will get legal opinions for, to assist, especially if it's an issue that is not only isolated to that municipality. If we see something is now cutting across a lot of municipalities, we will get our HOD and our minister to agree to appoint us a legal expert to then help those municipalities. Otherwise, they go to court. Developers take them to court, and then they don't have the money to defend. They often just abide by the ruling of the court. And I think when you abide, you often lose those court cases. Yeah. So, and I don't think it's going to become easier, Chair. This is a battle that will probably just get more difficult. Thanks.
Yep. Mr. Rebel, anything you want to add?
Thanks, Chair. Yeah, just on Member of Constable's remark on the bylaws. We've drafted the initial bylaws, and most municipalities have adopted those at the time. And slowly we see them changing it to certain degrees. But what we also do is whenever we pick up difficulties or challenges that require changes, we take our own standard set, we adjust it where necessary, and we send it out to municipalities. So they always have a sort of an up-to-date example of what they can use. And most certainly after this process, and depending on what progress there will be with these Pluma amendments, we will definitely do the same. And what we then also do is in the regional planning forums for each of the districts, as well as the Municipal Planning Aids Forum, we discuss this and we advise them accordingly. And as my director has indicated, when there's a specific need and a specific request, we go there and we spend time there and assist as far as we can.
Thanks. Let's take Member Wessels and then Member Nkondlo.
Yeah, thanks, JP. Mine is maybe, I'm not sure what's happening now.
I think there's a mic on by the computer there.
Yeah, is it better now? Yeah. Okay, cool. Yeah. Firstly, exciting to see that the process or the framework allows for more municipal discretion. Although I think it's very, it is a admirable thing to do. I think it might cause trouble in the future because, as you said, planning processes usually becomes a political playground, if I can put it as such. But nevertheless, I think it is. Uh, it will help in a very over-regulated environment. I just wanted to ask, with this 45, the or section of the Act 45, to remove certain instances where a municipality must refer land use application for provincial comment, that is when it's outside the urban edge, we know SDF, which exists, which is as you said, not the case, an application that involves rezoning of land for agricultural conservation purposes. And then on the next page, 67, it then said we then spoke about Padala and the fact that there is that shortcoming where they can't piggyback of each other. So how would I mean, I fully agree that it is currently a extremely tedious process, and I take George as an example. George is not only there with a building that collapsed, maybe it's also quite a lot of agricultural land that is currently in process of being developed, the airport precinct, etc., etc. But these things takes an enormous amount of time and money for developers, and that is usually why it becomes a political playground in the first place. So how does these two then, will if it's outside the urban edge and agriculture land, does that discretion then falls to the municipality? But then that doesn't really mean anything because Padala will regulate that. I don't know how you pronounce that PDAL, but that will then put on, as you said, another year on the whole process. Am I understanding that correct? Because then we're not reducing the red tape, then we're adding red tape, if I'm not mistaken.
Before we come to that answer, we've got Member Nkondlo online. Member Nkondlo, hopefully you will be able to come through. So open your mic and speak.
Thank you, Chair, and good morning to everybody in the platform. I'm standing in here for Member Stoffels, who is a main member of this committee. Chair, I just want to know from the team, I am not sure, perhaps the documents would have been shared, especially the background documents would have been shared with the committee. That at least gives some context for one to read, especially in the background that was given by the presenter, including the court cases, that would have elevated the areas that are being corrected through this particular legislation. I'm interested to just understand whether is there such information, including an impact assessment that would have been done on the implications of the bill and the amendments that are being made, as I think they are already being raised in the various discussions that are happening in the committee. So if I can be clarified in that, I think that's one issue. I think my chair of agriculture, Honorable Masipa, has covered me on Pitala. And then I just want to understand, maybe explaining this concept of the urban edge, because I think I hear also Member Walters talking, and I think the presenter or one of the presenters was talking about this issue, that planning gets embroiled in what is viewed as politics, as if planning, especially planning of land, is not a political issue, because it is a political issue. How indeed what is termed in this context, and this is what I want to try and understand, what is an urban edge, what is within or what is without, what does that mean particularly as we are trying to evolve in the planning reform towards inclusion. So maybe you can just explain that to me so that I'm able to understand that. And then my last one is once again on the area on the personal notification. There, I'm trying to understand, maybe I might have missed the explanation, of the notion of personal notification and those, who are not affected, which I think the section indicates that some of those that are not affected may not necessarily be notified. I'm not sure whether that's what the amendment is saying. So if I can just be clarified on those issues, Chair. Thank you so much.
Thanks, Member Nkondlo. I think maybe just to add on to that, just very briefly, to kind of piggyback on that question, because obviously, you have different municipalities with their own bylaws. I mean, obviously, the City of Cape Town's got their spatial planning bylaw, and within that, it sets out certain things that would be deemed to be or having an adverse impact in terms of what one can object to when it comes to the tribunals. So, is there a kind of standard protocol when it comes to defining what an adverse impact would be? Okay, so we'll take the answers to those two questions, and I think after that, we must have a look at the way forward, because we are obviously going to have to look at a public participation process for this, and we can talk about dates and times and venues, etc. after that. So have a think in the meantime. Over to you, Mr. Munro and Mr. Rebel.
I will answer some of them. I've asked Mr. Rebel to maybe just prepare to answer the question from Member Nkondlo on the background and the RIA that we did right at the start, the impact assessment, to start the process. And then maybe also on the personal notification, how that works. But Member Wessels, yeah, so the board discretion, it was an evolution. Planning has been over 100 years a provincial function. So when the province was asked to hand over this power to the municipalities, it didn't come easily. In fact, the first versions didn't give the municipalities any power to take decisions. Even the appeal processes still sat with the minister. So it happened very quickly in the last year or two of the Act's development that we realized that the decision takers are going to have to be the municipalities. So, and there were very last minute amendments that we introduced. And as the Western Cape, we actually introduced the concept of bylaws to the rest of the country. But in that process, the province tried to hang on to some power. They said, okay, municipalities, you can take these decisions, but you're going to have to ask us, for certain things still, and what that was about was big things, new towns, things that affect provincial mandates like agriculture, conservation. You got to come to us, and we had the Section 45 that you referred to sort of force municipalities to come to us, and we are stepping back from that now. We're participating in the processes like always, and as I say, as the trust relationship with the municipalities grow, they will ask us, for comment. So the provincial functional areas, if it's next to a school or affect a school, of course, they've got to come to province because education is a provincial mandate. It's probably also our property. So that doesn't affect that. But the sort of hands-on big brother thing, we have to, I call it step back, and I know it's not, we've got to give them their space and let them govern these things. There are other processes. If you don't agree with something that you can take, you can even go to court, especially things like these mining applications on our West Coast, where to us it feels like our national colleagues are just handing out these mining licenses left, right, and center. We've got absolutely no say in that. We will go to court on some of those if we have to. So that clause had to do with stepping back. Section 61, which is the exemption clause, that what we try to do there is if you are being regulated by Pedala, in future currently Act 70, to subdivide an agricultural land. We give you exemption from our process. We trust that process. And I think that's something that we must do across the board, you know, with environmental impact assessment, heritage impact assessment, water affairs. If the best department, best equipped to deal with a specific issue, like subdivision of agricultural land, we as planners don't know, you know, whether a 50-hectare farm in the winelands is big enough to be economically viable, whereas the same farm in Karoo might be 3,000 hectares, you know, is that we leave to agriculture. But what we say here, if it's a bona fide agriculture subdivision, you don't need the municipality. So there we save you that time. So you can go straight to the Surveyor General down here with your agriculture approval and get on with it. But we just wanted to make sure that we cover everything. As Mr. Rebel has explained, we accidentally missed the consolidation part. So we've just included that there to say that even if it involves a consolidation, you are still exempt. So that's an attempt to take one of the 7-8 steps in the planning process out of the equation. As I said, out of the 6.5 years that it takes. Theo will talk to the RIA just now. The Urban Edge, Council and Kondo. An Urban Edge is a tool that we've got to achieve many things in planning. More compact cities, that your cities don't just sprawl. Some of our towns are not as good with the containment of sprawl, and then you get, especially up north around the Kruger National Park, for those of you who've been there, the sprawl is incredible, and it's almost impossible to provide services to people in such low densities over such vast areas. No schools, no facilities, no services. It is impossible. So the urban edge is to keep a town compact and for it not to run away with you. It is also very important for spatial transformation. We desperately want the Western Cape towns also to transform also spatially with our segregated past. And if you don't have a strong urban edge, the rich will just run away. They will just go live in the vineyards. So it's an important tool for us, and most municipalities, fortunately, apply it fairly rigorously. City of Cape Town, for a while there, had politically, I guess, said we're not having an urban edge. But there is a line just beyond Melkbos, and if you go over that, you're on your own, meaning really on your own. There's no water from the city, no electricity from the city. You're welcome to establish a city over there. We know there was a big application. But when they started to do their maths, they realized you can't really go on your own. So it actually also acted like an urban edge, where the city said, our infrastructure reach, where we can help you with water, electricity, roads, and sanitation, as well as remove your refuse. That is our urban edge. And once this place is full, and there's a full is it's not the right word. Once the densities are there, and remember the densities are also required for your transport. Your MyCity system, bus system, cannot run if there's not enough people. So we can't go fetch people in Visante Kraal and in Stellenbosch, and it's too far. It doesn't make sense. Financially, it doesn't make sense. So the urban edge is that tool that helps us to shape our city. The personal notification, look, what we're changing is we're putting in the word adversely. The word adversely was not in there. Our previous legal advisors was Advocate Breitenbach, very respected. And at the time, that was the thinking that you not only have to affect somebody adversely, if you affect him in any way, even if it's a positive way, you need to speak to him. And that's now the problem with having to send letters to every single person in Camps Bay if somebody puts a carport up. As Theo mentioned, often that notification costs more than 100,000 rand, more than a carport. So what we just slipped in the word adversely, which now changes the whole ballgame. It means the city will have to determine who will be affected by that carport. And it's often just the close neighbors across the street, 2 houses up, 2 houses down. They must still determine who will be adversely affected. And that, I can't give an answer to that, Chair. It's going to depend on circumstances. If it's the block of flats or it's the carport. It's very difficult to have a standard set of things there. But the municipalities are often, they're scared to make a mistake. So they'd rather go wider than, and remember, it goes in the newspaper as well. So everybody can still see it. But that story of you living on the other side of Camps Bay, you haven't been served with an official registered notice. And now you can take on the city to court. That is now taken away.
And also the opportunity for possibly extortion, which I think does tend to happen as well. Somebody will object to something for a long period until they get a little payoff. And we have seen that in the past. Mr. Rebel?
Yeah, Mr. Chair, I just want to add on what my director has said. I think it was a question of member Wessels on the exemptions. The exemption from certain subdivisions and consolidations, especially where agricultural land is involved. Just to indicate that the Act provides for an option to do this. The Act doesn't say to a municipality, you must exempt. There are municipalities, and let me mention Witzenberg, for instance, that have not put that in their planning bylaw. Because of the intensity of agriculture in the area, they feel that they also need to have a say on. So even though you need a Act 70 approval for that, you also need in Witzenberg and I think Swartland as well. So that is where we say flexibility and autonomy. So we open the door for the exemption to be there, but we don't force that on. The other thing was the what we call a RIA, the regulatory impact assessment. We did that. I think it was, and I can't check it now because I'm in presentation mode here. What we had to do was to do what is referred to as a significant test. So we listed a whole lot of issues, even more than what eventually transpired into proposed amendments. Do a significance test to see, what will the impact be. These things mainly are not so much where you relax things as where you want to add additional measures. But eventually we did that significant test. We submitted it to the CRC, the province's central RIA, regulatory. The CRC is the acronym for it. But the conclusion was that the amendments that we propose are not so significant that we need to do a full regulatory impact assessment to answer that question. Is that documentation available? We can make it available. And on the question of the 2010 Constitutional Court judgment that led to a better understanding of the whole municipal planning concept, we can share that with the community administration. And if there's anything more, then the department is willing to share. But I mean, if we want to share everything, that's a huge lot of documents. Thanks, Chair.
Right, thanks, colleagues. I think we have exhausted questions. If we can then, sorry, Mr. Munro.
Sorry, I just want to introduce my Chief Director, Fazeka Mabusela, who's fought her way through the traffic, who has joined us at the end of the table. Thanks.
Thank you for joining us, Mabusela. I know colleague member Masipa sent me a photograph of a golden arrow bus that had smashed into a car. which I think even added more to the to the troubles on the road. So yeah, we feel for you, and we're glad you're able to join for the majority of that presentation. Thank you, colleagues. If we can then move on, just staying on this item, in terms of the way forward with this legislation, as mentioned, we are going to have to go out on public participation, and it is recommended, or I'd like to recommend, that we do undertake public hearings. The venues and the locations of those public hearings, we would still need to be determined, but I would recommend that we choose 3 locations apart from the city of Cape Town. So we could have one here, one public hearing here, and then to look at the a venue on the West Coast, a venue on the East Coast, and then potentially something inland. And I'm going to ask Member Constable for a recommendation for an inland venue. I think he might give us a proposal there. But if we're looking, for instance, colleagues, at areas where this would be quite pertinent, I think there's a lot of development going on at the moment in the Plet-Knysna corridor along that side, as well as in the Winelands, and obviously the city of Cape Town. So if it's all right with you, perhaps myself and Mr. Kutsia could come up with some recommendations which we can then circulate, as well as some possible dates for those public hearings. Member Constable, do you want to input there?
Chair, no, I think the garden would be the third one. I don't think Central Karoo is so into planning, maybe next year, because there's a lot of stuff coming. But for now, I think garden route would suffice.
Fantastic. So we can then get away with 2 plus the city of Cape Town in terms of those recommendations. And we would then also have to look at the identification of newspapers for adverts, and the duration of the advert, which is normally 10 days. Also some social media around it, and to put it on the Western Cape Provincial Parliament's website as well. And then stakeholder-specific letters. I think this is quite an easy one. You can send it out to the ratepayers associations and the civic associations. I'm sure they would all be very keen to give inputs. But at least, it's a way for us to ensure that when we have these public hearings, we have people who are attending and speaking on the item, on the legislation, as opposed to spending taxpayer and ratepayers' money on public hearings that actually don't really have much to do with the legislation at hand. Are you happy with that as the approach going forward? And then, as I say, we'll communicate in due course with some recommendations. All right, Member Wessels.
Yes, Chair, thanks. Just tongue in cheek then, taking from what Member Constable said, we can assume then that the Beaufort West Dubai is just on the back burner for now.
We can scrap that comment.
Mr. Wessels must come. Member Wessels must come and visit us next year.
Oh goodness. All right. Thank you very much to Mr. Munro and your team and the director. I think, if there isn't anything further, you are released, and we'll take a 5-minute break and come back. Yes? Oh, sorry, Member Nkondo has her hand up. We didn't have it raised. Sorry. My apologies, Member Nkondo. Please go ahead.
Thank you, Chair. I just wanted to check whether is it for financial reasons why the public hearings could not be held in all the 6 regions, given the far-reaching implications of this type of a bill? Thanks.
Thanks, Member Nkondo. Yeah, I mean, look, I think that is a consideration, is the cost of it. But we can certainly look on extending that. As I say, Mr. Kutsia and myself will look at some options, present those, and if you want to make additional recommendations for venues, we're more than entitled to. We're guided by the members of the committee. So if the committee decides they want to do 6, then that's the decision of the committee. But let's get some recommendations in place first, and then give some inputs after that. All right. Thank you. Colleagues, we're going to take a quick 5-minute comfort break, and then we'll come back and deal with the independent municipal demarcation legislation. Thank you. There is tea and coffee, yeah. All right, colleagues, sorry, that was a little bit longer than 5 minutes. We are going to reconvene. Member Nkondla, I see you've got your hand up. Is that a legacy hand, or do you want to raise another question?
No, I'm sorry. I'm sure it's a legacy.
No problem at all. All right, colleagues, we're just going to move on now to the comments and the adoption of the negotiating mandate report on the Independent Municipal Authority Demarcation Bill. As you'll recall, this was one of two pieces of legislation that we took to public hearings in those three locations across the province. Just some background, the draft negotiating mandate report was sent to all members on the 23rd of July 2025. So all members have received that and had sight of it and an opportunity to peruse it. During the 6th Parliament, our Standing Committee on Local Government submitted a negotiating mandate on the bill. However, as we know, the committee noted that due to insufficient timeframes, it was unable at the time to conduct public hearings. The Select Committee at the NCOP did not conclude the bill at that stage because of the election. And the transition from the 6th Parliament to the 7th Parliament, during that time, the bill lapsed. When a bill lapses, it ceases to exist in law and it's removed from the legislative process. Consequently, the mandate, which is intrinsically linked to that bill, also lapses because its legal foundation disappears. There's no express provision in the Act for mandates to survive or to be revived after a bill lapses. The current context involves a transition from the 6th to the 7th term of Parliament and the provincial legislatures, which implies a changed electoral mandate and potentially a changed composition of Parliament and the provincial legislatures. Following the revival of the bill by the National Council of Provinces during the 7th Parliament, this committee received a briefing from N. Matyai of the Department of Cooperative Governance. Mr. Rikus Badenhorst, a permanent delegate of that committee, was also present at the briefing. The committee received legal advice that although the bill was revived from the stage that it was during the 6th Parliament, the negotiating mandate could not be revived, and therefore the committee would have to adopt a new negotiating mandate report. At its meeting on the 31st of March 2025, the committee resolved to hold 3 public hearings on the bill. Hearings were advertised in Die Burger, Cape Argus, City Vision, Ons Contrai, and George Herald. Invitations for public comment were also sent to Salga and all municipalities within the Western Cape. Public hearings were held on the 23rd of April 2025 in George, 29th of April 2025 in Vredendal, and the 30th of April 2025 in Cape Town. Cape Town hearing was also a hybrid hearing. Although the public hearings were well attended, only a limited number of submissions were received. So we do have the draft committee report, which has been circulated to all members. And in terms of that, I just want to read out the beginning, which states, the Standing Committee on Local Government, Environmental Affairs and Development Planning, having considered the subject of the Independent Municipal Authority Demarcation Bill, B14B 2022, referred to the committee in accordance with Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to not support the bill in its current form and proposes amendments as reflected in this report. The committee will reassess its position on the bill during the final mandate stage, contingent on whether the proposed amendments were considered. And following on from that, all of the proposed amendments are then included in that draft report. Colleagues, I put it then to the committee that the draft committee report be adopted. Are there any objections to that? No objections?
No objection, Chair.
Thank you very much. Then we will proceed, and that is noted, Mr. Kutsia. That is the end of that item. If we can then move on to the next item on the agenda, which is the adoption of our draft committee minutes, which were also distributed on the 31st of July 2025. Those minutes as mentioned, have all been distributed and those are available. Can I have a proposer and a seconder for those minutes? It seems that everybody here was present at that meeting. So do we have a proposer, Member Vessels, and a seconder, Member Constable? That was the minutes of the 17th of June 2025. All right. Just give me 1 second. And then, colleagues, I think apart from that, we don't have any other items aside from the resolutions. Is that correct, Mr. Kutsia? Yeah. All right. Colleagues, are there any resolutions coming out of today's meeting or anything to be proposed? I know we have already discussed the issue around the public hearings and all of that, which we have agreed that we'll take forward. So that doesn't need to be discussed further now. But are there any other resolutions that anybody wants to propose coming out of the meeting? Member Vessels?
Thanks, Chair. Chair, I was sort of following on to this amendment bill, but maybe slightly different. I was wondering if the department can provide us a report with all the planning turnaround times, average turnaround times of all the municipalities in the Western Cape. They should have that data, and it would be quite interesting to see how the it would speak to a lot to the capacity, firstly, within the municipalities, and this bill is to capacitate the municipalities, but it would also speak to a lot of the red tape that municipalities might be finding. So yeah, that's
Great.
something that.
So just for clarity, so it's a presentation on the sort of start to finish of the development application process for applications across municipalities.
Yeah, but it can also just be a report. They don't have to. It doesn't have to be a presentation. I'm sure that the system will have rezoning and all of those sub stuff, and just to understand the average length of time that municipalities take with regarding to planning processes.
And would you like that as a presentation to the committee at some stage, or just as?
I will leave up to you, Chairperson. I'm happy either way.
I think we should consider that as a presentation. I do think it's a very good suggestion, and yeah. So let's see if we can schedule that at some stage. Thank you, Member Vessels. Anything else, colleagues? No other hands?
My hand is up.
Oh, Member Nkondo. Sorry, Member Nkondo. Mr. Kutsia's screen he's just flipping between the minutes and the meeting, but we've got it. Perfect. You go ahead.
No, thank you, Chair. Chair, I would like to request if the documents have been circulated, the one on the rear that was done before. I think the presenters referred to that, if such could be circulated, including, I think, the court case, I think they referred to in their presentation. Secondly, if the department can just give what is the definition, what is the current definition in the planning reforms, the evolution of the concept of the urban edge and the township development, and if those two in the current amendments, there would be any implications thereof, on both the urban edge and township development. Thank you.
Thank you very much, Member Nkondo. That's noted, and we will make sure that we send those requests through. All right. Colleagues, thank you very much. I think this was a very interesting meeting, and we're going to have our work cut out for us with this bill, the new one. I do think it's going to generate a lot more interest than maybe we think. But yeah, Thanks very much. And we'll see some of you back for Member Masipa's meeting later this afternoon at 1. The meeting is adjourned.